Welcome, everyone, and thank you for joining us this evening for our March webinar, Special Education Legal Fund's March webinar titled Special Education Advocacy 101. My name is Christine Lai, and I'm the Executive Director and co-founder of Special Education Legal Fund. I'm so pleased this evening to welcome our distinguished panelists and everyone who's joined us for tonight's discussion. First of all, Special Education Legal Fund is pleased to announce our 2021 sponsors of the Parent Education Panel Series: Winston Preparatory School, American School for the Deaf, Chapel Haven, Villa Maria, Fusion Academy, and Hubbard Day School. Thank you to all of our corporate partners for participating in this initiative. Before we begin, I wanted to share a few words about Special Education Legal Fund with all of you, especially if some of you are unfamiliar with us. Special Education Legal Fund, or S.E.L.F, was founded in 2018 to provide grants for families in need with children in the special education system. Since our founding, we have provided over $330,000 in grants for legal support from qualified special education attorneys to nearly 80 families in 32 school districts across Connecticut and Westchester County. For more information about the grants program or to begin the application process, please send me an email at christine@spedlegalfund.org. I will also put my email in the chat so you can email me at your leisure. Families are eligible for this program if they have adjusted gross income of below 300% of the federal minimum poverty line, which for a family of 4 in Connecticut is $76,400. You must have a child with an IEP, and you must live in Connecticut or Westchester County. We are currently accepting applications from families in all school districts in those areas. Our next application deadline, we accept applications on a monthly basis from October through June, and our next deadline is March 22nd, which is the Monday after next. Our webinar schedule for the rest of the year is as follows. In April, the panel is going to focus on post-secondary transition programs, and you will have the opportunity to hear from Christy Chandler as she talks about Chapel Haven's ASAT program, as well as John Savita from Winston Transitions and Lauren Macbeth from Westport College Prep. In May, we're going to convene a panel of special education attorneys, including Jeffrey Forte, Robin Keller, and Piper Paul, to discuss the very topical issue of summer slide and extended school year. And finally, for June, our panel of special education attorneys are going to discuss the year in review. That last panel will include Andy Feinstein, Courtney Spencer, Christina Gio, and Michael Gilbert. For more information about these panels, you can follow us on Facebook or Instagram at SPED Legal Fund, and you can also register the same way that you registered for this webinar. So now, Julie Swanson. It gives me great pleasure to introduce all the members of the panel tonight, starting with Julie. Julie is an experienced special education advocate, the mother of an adult son with autism, the co-author of Your Special Education Rights, What Your School District Isn't Telling You, and the founder of Life Skills Lady, which is her passion project devoted to increasing life skills and positive outcomes for students on the autism spectrum. Welcome, Julie.
Thank you.
Diane Willcutts is our next panelist, and we're absolutely thrilled to have her as well on this panel. Diane is also an experienced special education advocate with over 20 years of providing service to Connecticut children in need of skilled advocacy services. Diane is active in a number of organizations, including Rights Law, the Council of Parent Attorneys and Advocates, or COPA, as well as the Learning Disabilities Association, Autism Spectrum Resource Center, and the Academy of Orton-Gillingham Practitioners and Educators. She has also been an instructor for COPA's renowned SIA training program for advocates. Welcome, Diane. Next up is Anne. She's our next panelist, and we're absolutely thrilled to welcome her as well. Anne Munkenbeck has been providing support for families and their children in navigating the special education process for many years, with a focus on empowering families to effectively advocate for their students. Anne is an active member of the special education community as a board member of ABC Wilton, as coordinator of the College Advocate Program, an instructor in parent training for smart kids with learning disabilities, and she's currently pursuing a master's in special education with a concentration in assistive technology. So welcome, Anne.
Thank you.
Sorry, everybody can hear my paper rattling around. Finally, last but not least, I'd like to welcome Virginia Blum to the panel. I've actually known Virginia for quite a long time, and I first came to know Virginia as a mother whose advocacy skills on behalf of her daughter with autism truly blew me away and formed the inspiration for her career in special education advocacy and the basis for her practice on behalf of students and families. Welcome, Virginia, and the rest of our panelists to tonight's webinar.
Thanks, Christine.
Oh, and last but not least, of course, Lara Damashek is our moderator for this evening, and she's a board member of S.E.L.F, a wonderful friend of mine, and a very often moderator of these panels for S.E.L.F. Lara is a special education advocate in Connecticut who was previously a special education attorney in New York City with the law offices of Regina Schuyler. Her experience as an attorney, as well as a public school teacher earlier in her career, and a parent who has navigated the special education system for her own child, gives her a unique and compassionate perspective for families and students. She's also one of my favorite people, and I'm really excited for her to moderate this session as well. So I'm going to stay on the panel, on the webinar, providing the very valuable back-end support. And if you have questions for any of the panelists, please email them to me at christine@spedlegalfund.org. I will put that in the chat again. And the all-important disclaimer, this webinar panel is presented for informational purposes only. This webinar is intended as a resource for families who are navigating the special education system in Connecticut or New York, and is not intended to provide legal support, advice, or assistance to any particular individual, nor is it intended to replace the advice and counsel of a qualified special education attorney or advocate. This webinar should not be construed as an endorsement by Special Education Legal Fund or any of its representatives of any of the participating attorneys in the panel, or advocates, I should say. For webinar participants, this panel should be viewed as a public forum. Please do not ask questions in the Zoom platform, either in the Q&A or the chat, about your child or your child's legal or educational situation. Please email questions to me, Christine@spedlegalfund.org. In your question, please refrain from any comments that include identifiable information about your child, including name, grade, school, or school district. Please remember that your screen name may be visible to the participants in this panel, as well as the panelists and Special Education Legal Fund. And finally, this webinar is being recorded and may be distributed or shown at a later date at the discretion of Special Education Legal Fund. And now over to you, Lara.
Okay, good evening, everybody. So I'm so excited to hear from this wonderful panel of advocates. If you wouldn't mind sharing to start how each of you became a special education advocate, a little bit about your inspiration to do this work for us. Anyone want to start?
I'll jump in, Laura. I'm Virginia, and for me, I fell into the work because my daughter was a child diagnosed with autism at the age of 2.5, and advocating and working through the process. She's 18 now and doing great. And I just felt like when she sort of needed me less, that I was passionate about this field and wanted to help navigate that process for other families and share what I had learned along the way. And I find it, I can relate to families because I've been the parent sitting in that seat at that PPT meeting and feeling helpless and powerless and maybe not asking the question correctly. And so I enjoy giving back and helping families and teaching them to advocate effectively for their child.
I'll follow up as I think a natural follow-up to Virginia, in that I'm probably, my son, who also has autism, was diagnosed about 10 years before your daughter, Virginia, back in 1994. And these are what I call the dinosaur days of autism, because there were no cell phones. There was no social media. I had to look up autism in a 1950s red set of encyclopedias at my local library. And it was really nobody knew what ABA, applied behavior analysis, was. Nobody knew what a board certified behavior analyst was. There wasn't one BCBA in the entire state of Connecticut. And I had to unfortunately bring my district to due process because they refused what we were asking for. And it was a very good outcome. And after I prevailed, autism, we all know what happened. It shot up out of, just like a rocket. And all of a sudden people started to call me and ask for my advice because they knew that I had prevailed in the second due process case in the entire state of Connecticut for ABA. And all of a sudden, as time went on, I realized, wow, people need help. And, it just happened. And all of a sudden I realized, I think I should be doing this. And that's how I got into it.
Thank you so much. And do you want to chime in, Diane? Or
oh, sure.
Dan?
Like most advocates and attorneys, I too have a child with a disability. Actually, I have two. I've got one with high functioning autism and one with dyslexia. And so it's just been a party at my house. Starting off, I remember going to all these PPTs and wondering, why are people not listening to me? Or why do we have the same conversations over and over and over? And I became a little bit obsessed with conferences and workshops and just general information junkyism. And as a result, at one of my conferences, one of the attorneys said, "Oh, I just assumed you were a professional advocate. You should go do that." And I thought, that sounds like an interesting idea. And I decided to start off slow. I wasn't going to advertise. I would take one client, and I never looked back. I mean, I think what people find is advocacy is a word of mouth business. And so people primarily come to us through referrals. And, so it's a tough field. On the one hand, you have to be very comfortable beating your head against a wall. On the other hand, it's really rewarding because you get to make a really significant difference in people's lives.
Yeah.
So, yeah.
And Diane, you and I started out at the same time.
Yes, we did.
Yes.
So,
when there were hardly any advocates in the state of Connecticut.
That's true. Yep.
And do you want to just share before we move on to the next question? What brought
Sure. Like everybody else, there are some family members. We have identical twin girls that were born premature, and our world was turned upside down. And we started with services with birth to 3. And so at this point, they're 26 years old, and they've graduated from college, and they are immersed in their careers. So it was a real journey. About halfway through that journey, I had many friends and family members who knew that I had some level of knowledge just from experience with working with this, and had done extensive research and finding other resources in the area. So people would ask me questions and say, "What do I do about this?" or "How do I solve this problem?" And my responses always were taken very favorably. And in addition to that, it worked. So they always found the response back to me was they found that my advice was not only helpful, but when they brought it to the school team, they saw results. So I thought to myself, wow, I've heard about this field about special education advocacy. I should look more closely into it. And so that's when I got involved in trainings, nationally, locally, at the state level. And now I'm learning more about assistive technology with my master's, which is a really interesting kind of a field that is growing in leaps and bounds, and it's exciting.
And given that you're all special education advocates practicing, can you tell us a little bit, or maybe some of you want to speak to why a family would contact an advocate versus an attorney? What are the main differences, and what do you feel are the advantages of working with an advocate? But who wants to start this one? Julie, you want to take this?
Sure. Well, generally speaking, if you're not at a juncture where you're in a complete disagreement with your school district, right? You still have room for an advocate to get involved, right? So the second that it's gotten to the point where either the school district disagrees with you or you disagree, and you are heading off to a hearing or going into a due process, there's lots of wiggle room and an opportunity there for matters to be resolved by an advocate. And so I always say, even sometimes when something is right on the cusp, I will often say to parents, well, you know what, you can try to resolve it at my level and maybe I'll get it resolved with you, with me, hopefully I will. But if not, you'll be all teed up to take it to the next level if unfortunately it has to get to that. And
so when you say you'll be all teed up, you mean you've given them the guidance they would need, you've laid the groundwork for pursuing it.
An attorney would not have to do anything coming in because the record will have been made.
Right. So speaking about that record or, the problems that you are addressing, what are some of the main reasons that people contact you currently for special education advocacy? Diane, do you want to?
Sure. I actually find that a lot of people show up because they are hitting a wall with the district, so where they are reaching disagreement, or they feel like, gee, the district's not listening to me, or what are the magic words, because I can't figure out why nothing is changing. And at that point, because usually they don't even know we exist. Right. It isn't usually until there's some concern that they discover who we are. And then, I basically say, listen, I'm here to help you navigate the process. So I can do anything up until, as Julie said, a due process hearing. Advocates are not allowed to represent families in due process hearings. But if we do our job right, absolutely, worst case scenario, if you ever end up having to go, your file is ready to go to the attorney and they can run with it. At the same time, just to keep in mind, not to scare people, because the vast majority of families never have to go to a hearing. And even if they did, 95% of those cases resolve without a hearing. So just to not make people nervous. But there is a set process. So, you go to the PPT, you reach agreement or disagreement, and then you can go to the next step if you need to. My goal is to make sure that people aren't going around in circles, meeting after meeting after meeting, and to make sure that the family has what they need to strongly encourage the district to do the right thing. And and it can make a difference.
And I just will add quickly, I'm often struck when I pull out the IEP and the family has gone through. I've been saying this 6 times. And I look at the box that says parent concerns on, before you get to the plop, page 4, and it says the parent is in 100% agreement with everything that was said at the PPT. And I read that statement to my family as a way to say, look, part of my job is to teach you how to read your document so that you know where to look. And that's what it's a little bit harder in COVID, I find, just because I can't go page by page sometimes. But part of that is after a meeting, I'm taking notes. The family might be listening or taking notes. But when I get the document back from the district, it's me going back through it and making sure that we have documented what we asked for, and teaching the parents where to look at their document and read it so that they understand what they have agreed to or haven't agreed to. And I find if I can point them in the right direction, a lot of times they can become more effective advocates for their children, and they can take over and do a good job with it. That's
a great point, Virginia. I always say to parents, I want you to not need me. I want you to learn from me, right? And so it's a really great point.
Yeah, I always feel like it's a big win when the parent isn't calling me very often, because they've figured out the language to use. They understand the documents that their child has. They understand their child's disability and the impact it has on their education. They know the team well enough and have a good collaborative working relationship with them. And so I might just have to be involved occasionally for, for the annual PPTs and not so much at a granular level. In the beginning, I feel like it could be overwhelming for parents, and there are so many different moving components to it. There's the process itself, there's the child's disability, there are all the evaluators to try to figure out and work with and interpret what the evaluations mean and impact on their education. So the details can be really overwhelming for families. So I feel like my job is to sort through all of that noise and create a succinct document where they can refer to and say, oh, I see where this piece fits and that piece fits. And also, as you all have said, is educating the parents so that they can start to manage a lot of this or all of it on their own.
Right. It's really like learning a whole new language.
Very much so. We've all had so much training and experience in education in this particular field. It's a very niche field, but it's there's massive amounts of knowledge to amass and learn how to navigate the process.
So when you're talking about the process, obviously there's the I guess representation at IEP meetings itself, but what else would you say are the main reasons parents seek out your help? Is it for initial eligibility, or are parents finding their students are not getting appropriate services in public school? What do you find in Connecticut in your practices are the reasons that are some of the reasons people are seeking out your help now, COVID related or not?
For me, generally, it's what was said earlier, is that parents have kind of hit a wall. They know that their child is not doing well in school. They don't necessarily understand why that is, or if they do understand why, they don't feel like the team has the same, I need to be politically appropriate, right? We'll listen to them at a level that they would hope that the team would. And so to have somebody on their team to help voice their concerns and to create an environment that's collaborative and also understand the language that the school understands. Sometimes it's just framing the question or framing the concern in the appropriate language that can be helpful, but all kinds of reasons. Sometimes for me, it's a parent just needs help figuring out how to schedule a PPT at a time that's convenient for them. I mean, that was one of the latest that I had because the school was refusing to do that. So that was, a very kind of quick.
That's an easy one, Anne.
Yeah, it was an easy one.
That's
no problem.
Get it out of the ballpark.
How to figure that one out, but the parent, the school just refused. So they were stuck.
Right. So that's our key phrase for the day, perhaps, is if it's not in writing, it never happened. Mm-hmm. So absolutely always put things in writing. So if, say, someone's refusing to give you a meeting or saying it can only be on this day, you put it in writing and you explain why you need a different day or why you need it to occur sooner than 3 months from now, and document what they've said and say, gee, I don't agree. Here are some dates I'm available. And typically that resolves in about a minute. But people don't always realize. They think, well, I had a conversation with the principal or the teacher, and that person said we can't do it, and they assume that that's the case. And very often we find once we put it in writing, you get a different response because people recognize a paper trail, and they know, so it tends to make a difference.
I was going to ask, what would optimize a client's, initial consultation with you, a prospective client, and I assume you brought up the paper trail and the documents. Mm-hmm. So if you could give advice to future prospective clients out there, you'd say paper trail. What else is most helpful for that prospective client to keep in mind to get organized to meet with an advocate? What would you typically need to see?
Typically, I like to look at records from the past 2 or 3 years, IEPs, evaluations, report cards, any discipline notices, restraint and seclusion notices. I tend to do a partial records review up front so that I can ask better questions during an intake. So that's to better guide things. People are coming, they sometimes know what they want, sometimes they don't know what they want, sometimes they don't know what the child needs. And so that information at least gives us a basis to start the conversation.
What we
And just
suggest clients to do for S.E.L.F. Before they go and meet with an attorney, once they've been approved for the through the grant process, is very often I suggest that they put together a timeline, or at least write out their story in a cohesive fashion. Because if you've sort of written it out, you make sure that you haven't forgotten anything, that you have the dates and the times and the years and everything sort of correct, so that when you go to meet with your advocate or attorney or whoever the professional is at that point that's helping you, that you have a coherent narrative, and it's not like, you're just going on about, like, because it gets so emotional that, the conversation, can quickly go in many different directions, and you want it to be targeted, especially if you're dealing with an attorney, but also if you're dealing with an advocate, because it's, time is money, and that's important.
I was just going to throw in as a parent tip, the thing that I did for my own daughter that I find really helpful is anything that I got from the school district, I had a binder per year. And I kept every document that came. And it wasn't so organized in the way that I might look at it with my own client practice, but at least it was date ordered, so that if, I said, oh, we had a PPT on this date, I could find it in that binder. And so a tip for parents out there, that's important enough. And you are entitled to ask this district for a free copy. And sometimes they get it, they're supposed to do it in 5 days. Sometimes it takes a little longer. So I keep the binder, and I just think it's a good tool to help you. And the timeline's great too, but trying to keep your documents organized by at least school year is helpful.
And
I have a question, actually. I'm sorry. I have a question from the chat, from the audience. Are there any matters where, a client would come to you and you would say, I can't do that? That's a due process matter. And in this particular individual is asking about, restraint and seclusion, or, with regard to, the professionals that work with their child. Like, if your child is being restrained, an abnormal amount of times, or, how many, like, is that something that can be dealt with, with your support, or is that something that you feel like needs to be, escalated a bit?
I would say absolutely it can start with an advocate. Go ahead, Diane.
Oh, no, go ahead, Julie. I was
going to say, because at that juncture, you may not be in disagreement with something. You may not like the fact that that's happening to your child, and perhaps it shouldn't be, right? But that's where an advocate can come in and figure out what's going on. Why are they doing that? What assessments can be done so that we can get more information on how to put a more appropriate plan in place for the student. But, listen, restraint and seclusion is a very hot button emotional issue. And if your child is being restrained and secluded, and, there's not a plan in place to avoid that, that is something that an advocate can very much help you out with.
Right. And it indicates there's a big problem with the program.
Sure.
It is not part of a child, it should not be part of a child's plan that they will be restrained or secluded under any circumstances. So if that's happening, there needs to be an immediate PPT, there needs to be an immediate conversation about changes to the program, any assessment. But yeah, sometimes the districts will say, we don't need to have a meeting after every single restraint or seclusion. And for me, absolutely you do. And you need to go through moment by moment exactly what happened, so that you can make sure this doesn't continue. Yeah, and I know we all feel really strongly about that.
I think as advocates, we're especially, well, I could speak for the panel here, we're all very experienced in this process, and we know pretty quickly whether this is something that should be handled by an attorney or whether an advocate can help the parent go forward. And I think we're all very honest about that from the beginning. I had a call recently that was clearly something that was out of my purview, that was going to involve some legal wrangling that I'm just not trained or should be involved with in any way. And so I immediately referred to attorney and said, I'm happy to continue working with you and do some of the background information gathering and et cetera, but you are going to need an attorney in about a week. So my recommendation is that you contact.
Right. If there's any criminal charges, I refer to an attorney immediately. If there's a situation where DCF has been called, I also refer to an attorney, preferably one who's got a real solid special education background, because all of that, you can't really tease out the disabilities part from the criminal part sometimes, or you can't tease out the sometimes DCF is called in retaliation for a family's advocacy. A special ed attorney has knowledge about retaliation issues, for example. So that could make a difference in terms of how they approach the case. Whereas if you went to someone, if it's a criminal issue, if they just do criminal cases, they're not necessarily going to understand the impact of the disability on what happened.
And I was going to just jump in and say it's rarely, it does happen that you refer right to an attorney, but I think we all in our practices get to a place where I've done what I can do and we need, we're not getting what we need. And then I do refer to an attorney. So recently I've had 3 cases that have gone to attorneys. And like the panel said, I've teed it up. And hopefully it's less work that the attorney has to bill out for, and that's helpful for the family. But that is part of my job. When it gets to a place where I can't be effective, I'm absolutely the first one to say it's time to go. Right. And here's a great list of people that could all do that job for you.
Right.
I think the important point is that I think all of us here are very experienced in the ability to set a case up if it ever does need to go to that next level, so that we have dotted all the I's and crossed the T's and documented and taken the steps necessary to show that we've tried the best we can through the PPT process, but unfortunately, it's not going to be able to move forward in a sufficient manner. So we'll have to go to the next stage. And for the most part, that is helpful to the attorney because they have that background information, they have the files organized. I generally will continue to collaborate with the attorney when it goes to that next level, just because I have such a detailed and granular understanding and the information is all there. I understand the case, I understand the team, I understand the parents. So,
and oftentimes, Anne, to your point is, and it always makes me a little angry when as soon as an attorney gets involved, poof, everything gets resolved, right? Because, listen, I'm a big supporter of the public school system but unfortunately, sometimes there may be some districts who just want to see how far the parent will go, right? And so, an attorney gets involved and I'm like, but I did that and I did that, but I'm not an attorney, right? And they just want to see how far do we need to push you, which is quite unfortunate. But I think we've probably all experienced that.
Right. And there are some districts that just want to fight. Yeah. And there's one law firm in particular that represents school boards that just want to fight. They will resolve nothing in the PPT. They will file for a hearing at the drop of a hat over an independent eval. And in those cases, in those particular districts, I absolutely 100% send to an attorney right off the bat, because we just know which places are like that. Usually you can work it out, but not always.
So to your point, Diane, it's kind of an art that, as advocates, we have a sense of where a case might go relatively early on. So we kind of have this, I don't know whether it's a sixth sense or just knowledge base or experience, but it's for the most part, you can tell whether you're going to be able to move this case forward or whether it's going to hit a wall pretty quickly.
And like Diane said, knowing the players and who
Right.
the attorneys may be for the district. So the board attorney.
In most cases, when you show up with your clients, does that signal an attorney to come?
No.
Because it's usually
Sometimes.
Diane. Something you said, Diane, made me think of that. And I remember because I have a unique situation because I was previously a special ed attorney in New York, but I'm not licensed in Connecticut. And Connecticut, sometimes I work as an advocate. And I have to be really upfront beforehand that I'm not coming as an attorney to, if I've ever done a Westchester case, so that I can be sure that I don't want them to bring an attorney. I want to keep it kind of, cooperative. And what happens in most cases in Connecticut with you when you all show up at these meetings?
Typically, they don't send an attorney. However, there are some districts that always will. If I'm there, they automatically send their attorney. And I basically let my families know, listen, I'm fine either way, attorney there, attorney not there. However, if this makes you uncomfortable, and for some it really does, let us write a letter. Because really there is guidance from the US Department of Ed that says attorneys should not be at IEP meetings. They're just not supposed to be there, whether it's parent, school board, whatever. Absolutely, you have a right to bring an attorney to the PPT. The district has a right to bring an attorney, but the guidance is what it is. I find that if we put the district on notice, the family's feeling intimidated and they are concerned about an adversarial atmosphere at the meeting, one of two things happens. Either the board attorney is on their best behavior because they don't want to be a self-fulfilling prophecy, or they misbehave and we document it. So either way, it's fine. Yeah, but I prefer not having it. Well, sometimes attorneys are actually helpful. Sometimes
I was just going to say that, Diane.
Yeah, sometimes
they help the district.
Sometimes they help the district know what they have to do.
Yes,
yes. And sometimes when they are misbehaving, when we document it, we can actually use that to get better programming for the child. So,
right,
as I said, either way.
In my, I've been doing this for 20 plus years. In the beginning, when districts used to bring attorneys with me, I used to write the letter and say, you really shouldn't because I'm not an attorney. And as time went on, I'm just like, it's fine, come on along. It doesn't bother me. Because I don't think, like you said, Diane, there are circumstances under which that's not always the case. But yeah, they often will send their attorney. And I always say to the parents, don't worry, don't get intimidated, so.
And do you find that
the
school districts
go ahead.
are generally happy to have you there as an advocate? How do they, when you come in as an advocate and you're clear that you're trying to work with the district, how do the districts in general respond to your presence?
I think just as an aside, I just had a meeting the other day. I think the district knew they had not done the right thing. And with the family bringing the advocate, everything I asked for was immediately, oh, we absolutely are going to do that. Diagnostic services, absolutely. So, I left the meeting and said to the client, those are the kinds of meetings where just have me there and knowing how to ask, you got a much better program. So I find sometimes you have those where it's kind of like, well, now the client now the parent has gotten an advocate, so we better give them a little bit more. And sometimes the district is a little bit worried. And then as you start talking through it and they realize that you're trying to be reasonable and really just trying to shore up what the child needs, I think it's not adversarial. I don't think it's I think it's a conversation and we all shake hands, and at this point I know a lot of the people are the same people in every meeting I have. So I've had a meeting with them on Monday and I'm back in with them on Thursday.
You mean we used to shake hands?
Right, right.
Now we just wave.
And no shaking hands anymore.
I was just going to
Yeah.
say it's, I think it's really important to maintain a spirit of collaboration and professionalism, and to listen very carefully and make sure that you are covering all the bases the parent wants you to cover, but at the same time, listen to the district's perspective of why and try to problem solve. For me, it's problem solving,
Right.
you know, trying
Right.
to break that log jam.
Right.
But
Right.
I can say it's hard to know whether I'm a threat. I really don't know. I'm so focused on helping the parent. I'm not really assessing whether I'm a threat, because that's my primary goal there. Obviously, it's what I'm hired to do.
Yeah.
But I can say that parents share just what you said, Virginia. It's like things start to happen when I come into the room in a way that they hadn't happened before. And sometimes it's just knowing the language
Right.
that can create that environment. So.
Right. And people sometimes do worry that, oh, if I have an advocate there, it will be very adversarial. And if anything, it can sometimes diffuse a tense situation. I think in part because, you know, if the advocate is very professional and just is matter of fact, and gee, it sounds like we agree about this, sounds like we disagree about that, what can we do to try to, you know, resolve the difference? And also the advocate can help families, you know, who are inherent people pleasers. Sometimes I have families that are people pleasers and they're worried about making people feel bad, so they don't always ask for what the child needs. And so I can be very helpful in those situations. Or if I have a family that is going to lose their temper because they can't stand listening to this for one more second, we can prepare for that and we can talk about, okay, this might happen, that might happen. And so it's not as a volatile situation and they feel like, oh, my advocate will take care of this. You know, I don't have to panic in the meeting because my advocate's going to take care of this. And
It
I
takes
should
the
say,
pressure off of parents.
it does, but at the same time, I don't want to be, you know, I don't feel like, I don't ever want to lead parents to think that, you know, I can guarantee any outcome, because we can't guarantee an outcome. We know that, I mean, we can be as effective and as professional and all of that. Some districts are just going to be very resistant, but in those situations, what we do is prepare the case. And so,
what goes into preparing your client for the IEP or the PPT meeting? How, you know, what are some of the best ways you think a parent can be prepared, and what does that coaching look like behind the scenes with you and the client?
I always do an agenda, and I have, you know, it starts with the parent concerns and kind of builds from there. And a lot of times, you know, the parent and I will have kind of thought about it, and we have a call and we talk through it. And then there's certain pieces of that agenda that we share in advance of the meeting. So to Diane's point about being collaborative, I'm not trying to go in there with a lot of surprises. So if they've given me the drafts of what they are proposing, I'm going to send them feedback based on how we see it. And so everybody's kind of going to that meeting with a much more collaborative approach. There are sometimes some things that I don't send, but notes on goals and objectives or present levels or accommodations are all fair to send, you know, in advance. So, but the agenda process for me and having that meeting beforehand to kind of talk them through, this is my ask. You know, I might start with 5 hours, but if they give me 3, I'm going to be great. I'm excited about it. You know, I've sort of set the why I'm coming in where I'm coming in at.
Right.
But
you know, Lara, that's a really big question, but one of the things, because there's so many things that can be involved, right? But one of the things that I like to say to parents is, you know, I know you all have been to those PPTs where you walk out and say, what did we accomplish? Because you got into so much nitty gritty, you went down that rabbit hole and this rabbit hole. I like to say, you know, we need to go after the big ticket items and all the little stuff will fall in place, right? And also to think of an IEP team meeting as two columns of what we need to accomplish. What can we change today because we have enough information to change that? And what has a more longer lens, because perhaps we're going to need evaluations and we have to wait for that information. So what do you do in the interim, right? And, you're usually, things fall into what can be changed about the IEP goals and objectives, the service time, the, then you were talking about evaluations. There's so many things, but you really need to first go after the big ticket items. At least that's what I like to explain.
100%.
And I think part of my job is definitely to help the parents sort through all of that, to
Right.
come up with their own goals for their student and for that meeting particularly.
Right.
And the other part of that I think we've touched on is that as parents, we know this, it's an incredibly emotional time for parents.
Mm-hmm.
And so if an advocate's there, sometimes you can help the parents kind of put the emotions aside a bit and remain a little more objective. And hopefully that they're able to listen better to what the development is of the meeting, and to maintain a level of professionalism. So there are times when we've asked for the meeting to stop because the parent needed a minute to regroup, or didn't understand something, or might want to share something with me they hadn't shared before, which I don't like, but it's a surprise. But it can happen. You never really know. That not everybody knows exactly what's relevant at a particular time. But the other aspect is, which Virginia, you touched on, is to make sure that all the documents that you might want to share at the meeting, the team has access to beforehand, just in the same vein as if the team has documents that they'll be sharing, that the parent has access to them beforehand. So everybody is well informed going in. And
Great
it's hard
point.
to digest those documents on both sides. So
Right.
it's important that everybody has.
And that's a really great point, Anne, because so many times school districts don't provide the evaluations or material beforehand. So making a point of saying, you know what, even if we have to change the date, I'll make it later. I just want to make sure that you're able to get those to me beforehand. That's a really good tip.
Right. And just making sure that going into meetings, some of it sounds pretty basic to some families, but other parents don't realize that they don't want to go in and say, I want the best program for my child, for example, because they think, why wouldn't anyone want the best? But there's a legal-ish language problem. So everything is appropriate. I want what's appropriate for my child. I want what's necessary. I want what's meaningful, not best.
And so you help coach the parents.
So we to just make sure that they don't get tripped up on vocabulary. Another mistake that families will sometimes make is they might be overcomplicating. Staff, they might say, oh, you're all doing such a wonderful job, for example. Well, in special ed's, you're doing a wonderful job means don't change anything. And so if you say you're doing a wonderful job, but my child can't read, everyone's stopping listening after you're doing a wonderful job. So you can say, listen, I really appreciate the effort that everyone is making. At the same time, my child can't read and we need to do something different. So just things like that.
I'll share a little something with you, and I've felt like this for a long time, and some people may disagree with me. I've actually written a blog about it, and it's called Please Don't Call Me Mom. One of the things that really gets under my skin and is when the teams, what's that?
I'm like, don't call me your mom. I'm not your mom.
Yeah, I know.
Right.
I know.
You go to your, nowhere else in the world you go and somebody says, and how about you, mom? And by the way, and I've taken my own sort of incidental data on this. Rarely do they say dad to the dad.
They never say dad.
Yeah. Right. And it's just, so that's one of the things that I always will coach my, many of families I work with, is to say, you could very politely say, my name is Julie. Feel free to call me Julie. Because I think even though people on school teams may not realize it, it's quite demeaning. Right. And being a mother is the most proud job I will ever have, but I don't think you need to call me mom. Mm-hmm. And it sort of sets your level on the team. So, you know, everybody else gets to be called by their name. And I just think it should be, personally, it's just one of those things that just gets under my skin. So for whatever that's worth.
Yeah.
And when you're preparing for these PPT meetings, are there other professionals that you will collaborate with? Like, is there a team kind of, you know, that I remember kind of just referring to other professionals as like, oh, we're all part of like Team Mikey. I mean, in that case, I think it's okay to use the name. You're talking about the child, and hopefully no one finds that condescending. But like, you know, psychologists, or, you know, who are those professionals, and kind of how involved do you get with those professionals in preparing for meetings or just working on a case? So who makes up the different teams that you work with? Who wants to start? Anne, do you have?
Oh, sure. A lot of parents have private providers that they're working with. And if they ask me for a recommendation for a private provider, I don't make recommendations, but I might share a list of professionals that I'm aware of in the area. But I wouldn't be working directly with that professional, because their job is to be objective and work with the family for the student's benefit. If a parent would ask for some guidance on specific questions to ask a provider to try to get some kind of information, I might help them draft some questions, you know, by asking lots of leading questions like, what are you trying to learn? And what information do you want to gather? And just to help them define the scope of what they're trying to address when they're working with a provider, but generally not. I mean, I'm really, the parent is the one I'm working with. The parents are the ones that I'm working with directly.
What about in the case, you know, and this is for everybody, what about in the case of, you know, there's an independent evaluation that's been approved, and the parent, you know, really has no idea of where to go to, you know, to direct that, you know, that eval? Would you then, you know, be able to help them find someone that's appropriate? Is that something that you'd be able to help with? Assuming that the
Sure,
school
I can help them, but I'm not going to recommend anybody particularly.
See, it's
generally give them a long list to sort through.
And it's funny because I give them a list of like 4 or 5 people as a place to start, based on the fact that their clients have had success with them. I also give them a long list of questions to ask the evaluators so that they can get to know the evaluator and decide who's the right fit. It's always tough because I can recommend someone, and that day they meet with the child, they just have a different perspective than the family does. And that just happens sometimes. So I can't go in and guarantee that the evaluator is going to agree with the family. I'm always saying I don't recommend evaluators that are always going to say what the parent wants, that are always going to say what the district wants.
Right.
What I want are evaluators that are going to focus on the needs of the child, whether they agree with you or disagree with you. You want them to make very clear, specific recommendations.
Right. Right.
And I'll steer people away from certain evaluators that I know have a hard time writing clear, specific recommendations. You know, if the evaluator is reluctant, and some evaluators are, they're reluctant to give the frequency and duration of services, for example. Right. They want to leave it up to the school district. Or if I know the evaluator has said that they will never recommend a private placement no matter what, even if they think it's needed, then I would want the parent to have that information. And that's actually one of our questions on our list. So yeah, so I can recommend people to interview. And I can even say this one has a really good background in that, you should talk to them more.
Right.
I think that's an important thing to note is that, you know, just as there are evaluators that always say what the district wants, there's also evaluators that always say what the parent wants. And we all know who these people are. You know, everybody knows who
everyone knows who they are.
So, you know, it doesn't help you to have like a hired gun, you know, because everybody knows that they're a hired gun, regardless of what side you're on.
And the hearing officer, if you were ever in a hearing, is going to know they're a hired gun.
Yeah,
So that's, yeah.
But I think that it's really important, as Diane said, that it's such an individual process. Every family's different, every case is different, every child is different. So it's hard to predict what will be the best fit for a parent. And so they kind of have to delve into that journey with, guidance if they want it. I'm happy to provide guidance.
I like to say that an evaluation is only worth the paper it's written on if it does not have prescriptive recommendations. And oftentimes a parent will come to me, well, they will just have gotten this, evaluation that they paid a lot of money for. And I read it and I have to say, unfortunately, this is not going to get you an inch further than where you are right now, because it didn't make recommendations, right?
Mm-hmm.
And as advocates, we're only as good as the prescriptive recommendations that a professional puts forward, because we, the advocates, are not requesting the information. It is, we're asking on behalf of the professional, which is under the IDEA, what the district has to consider, the professionals, not us, right? So anyway.
Yeah,
right.
and there are some situations where evaluators will not put it in that document right away, which can be
and you want to know that,
but we'll share at the PPT. So it's nicer to know going in so families can prepare it.
I want it in writing. I basically am telling families, if the evaluator is not willing to put it in writing, then you need a different evaluator. Because sometimes they'll say, well, they told us in our meeting in their office, but they said they didn't want to put it in the report.
Right.
You need to know that before you hire this person, or before you have the school district pay for that person. And that's why you want to interview them and ask questions like, are you willing to make specific recommendations for frequency and duration of services? Are you willing to make recommendations about the qualifications that staff need to implement the program? It's just really important to have that information up front. As Julie said, you can get a really expensive evaluation done that, they might list 50 accommodations like extra time and seat near the teacher, but there's no actual instruction anywhere in there. So,
right.
Yeah.
We got a question that I know I'm just trying to keep my eye on the clock too.
Sure.
But a question that's come across, I think you might all be interested to answer. Can you ever request a board attorney to be present when you're trying to resolve an issue that you've repeatedly tried to resolve within the PPT meeting? So can you request that the board attorney be present?
I don't think that would typically help. Because the board attorney works for the district. And so if the district doesn't want their attorney there, I don't know that they're going to be that much influence. I would say that chances are, if you're going around in circles in the meeting, it may be that you're at a point where you need to ask for mediation or file for a hearing, or gee, did you put it in writing so that, is there a paper trail? Do you want to talk to an advocate to see if there's something else you can do at the PPT level? But yeah, I wouldn't typically, I just don't know how that would go over. Asking the director, can you please bring your attorney so they can talk some sense into you? I don't think that, I just don't.
Do you as the advocate ever ask? You said sometimes it can be helpful to have the attorney. No.
It can be helpful to have the attorney, but only if the district, I would never ask the district to bring their attorney. They don't represent me. They don't represent the family. So yeah.
I have had meetings, just in trying to resolve issues or at the PPT level where I've been in the meeting, we can't get anywhere, and we do go above the administrator's head and have a meeting with the head of special ed for the district. So that would be outside of the PPT where, we kind of lay out sort of, here's to Diane's point, here's the paper. And we're really hoping to work through this, and this is what we want. And sometimes in having that meeting outside of the PPT, when we go back into PPT, we've got a different understanding and the answer has changed.
Right.
So I do think that there are meetings that we have outside of PPT that help when you get into that meeting, kind of setting the stage. So
Lara, oh, sorry, Virginia, were you done? I'm sorry. Lara, to that question and to Virginia's answer, I always like to make sure that the director or a very high person up on the administrative level is at the PPT, because I think and so if you have perhaps somebody who, and I don't mean to diminish anybody who's a principal or a lower level administrator, but sometimes those folks may not have the inner working knowledge of what their legal obligations are as a district. And so I will most often make sure, matter of fact, always, but making sure a higher level administrator is at the PPT, so that you don't get in that situation where somebody who's the decision maker at the PPT truly doesn't know how to make decisions, and then that can become a time waster, because then you may have to do, like you're saying, Virginia, sometimes go to the higher level person. I'm not saying that you do that all the time. I'm just saying that's another tip. Know who your administrator is and introduce yourself, by the way, to the director of special education, and ask for them to be at your meetings. It doesn't hurt.
And I know
the other, sorry, the other part of that is to try to figure out who has the authority to make those decisions, because it isn't always at the school level, the individual school level. Sometimes the principal or the whoever is responsible for that area in special education for that particular school is tasked with going to the SPED director for the district and asking if this is something that they can agree to or not. So generally we'll make sure we ask that question if we're not getting a reasonable response. You know, who do we need to go to ask this? Is this
and they're supposed to have somebody at the district who can make those administrative decisions, but they often don't.
They're not
So
always there.
That's a really good point, you know, and to make sure that, as for parents, you know, to make sure who is the person on the team who's been charged with making decisions and has that authority.
And then parents, I recommend that they contact that person, you know, start off with an email and let them know what's going on, if they could meet privately and hopefully resolve the issue, or it can be very helpful. And many SPED directors are really open to meeting with parents and aren't always aware of all the tiny little things that are going on in the district, because there's massive amounts of students and massive amounts of information. So they can't possibly be on top of all of it.
Right.
So that can be really helpful for parents.
I've often thought that if all people who work in school districts, regular ed, special ed, were at least yearly trained on what their legal obligations were, we would not have the need for so many disputes. And because it is often that the folks under the special ed director are make mistakes that they don't even realize were mistakes. Mm-hmm. And so that's why it's such a great idea to make the special ed director aware, because he or she may not know that and want to fix it very quickly.
We have another interesting question that's come in. If you have a child in a placement with documented dangerous behaviors, can the district change the placement without the parents' agreement?
That's a tricky one. I was going to say no is the first answer. It's supposed to be a PPT decision. And even if there are rare circumstances where the child has, say, brought guns or drugs to school, and automatically the placement can be changed. The district can say, we're going to change the placement, but the parent still has to be included in the decision about where.
Right, because obviously they're proposing to change to a more restrictive placement.
Okay, and if the family wants to keep the child in the current placement, what they need to do is to file for a hearing to trigger stay put, what they call stay put. So the child stays in the school while the disagreement's playing out. But no, the parents have to be included in the decision making.
So they have, right, they have that injunctive relief. So you, that is a great protection, the stay put.
Yes, I love stay put.
You
Yeah.
call it, but it's a wonderful tool.
As much as someone can love stay put.
I know. Well, it works in a lot of situations. So.
Right, that wouldn't look so good on a poster. I love stay put.
Stay put.
Well, it does provide, I think the intent of the law was to provide stability to
Yes.
children while the parents in the school district are fighting. And so it really, like, I tend to be very hopeful, and that just gives me a little bit of faith in the system that there is, you know, the looking out for the child here when the parties are fighting, and right, that you can't just change the placement. You couldn't, and you're protected while the parties are fighting it out. And do you recommend outplacements to parents as an advocate? I know a lot of, you know, a goal is to obviously collaborate with the public school system when they can provide an appropriate support. But in what instances do you recommend outplacement, or do you not do that?
I do basically I raise the issue with the family, because some families really want to do in-district programming. Other families are open to considering outplacement. Believe it or not, I find sometimes the in-district program is harder to do if it's something the district doesn't already have in place. So you would think, oh, it could be cheaper. It can still sometimes be difficult. If the child isn't being successful in their school and it's not a quick, easy fix, I usually am asking the parents, do you want to consider other possibilities? And I will give them a list of places to talk to and some questions to ask them, just to explore.
You so I know a lot of parents will all look to advocates for placements and ideas of schools. Do you do that as part of your work with families? Give them referrals?
I give them, I say, listen, I don't know 100% whether this school would be the right fit for your child, but there are certain, this is what I know of the program, and here's the website and the phone number of the person to talk to, and you know, ask them questions. I do tell people to not get too attached to what's on the website, or to not be detached because of what's on the website, because the people who do the website are not the same people who run the school typically. And so there's different information on there. But to interview people and to find out, gee, do I think it might be a good fit? Do I want to go to my school district and ask for a referral packet to be sent to consider? But yeah, I mean, we consider the full range, you know, whether it's in district, maybe we need to bring in a consultant, maybe we need, you know, a particular type of instructor. Sometimes we want a team to come in and work with the child. But again, sometimes private placement is easier.
And I just wanted to caution, like, I have a lot of parents, sometimes either they call me off the bat, or you know, they jump to outplacement before I do. And outplacement's not, you know, the end all be all in terms of solving every problem. So, you know, I do certainly recommend it. And I have referral packets have gone out for clients that I have, and I've outplaced for sure. But I also have clients that I would say, but, you know, the downside is this, or, you know, your kid is now going to be with all special needs kids. And maybe that's appropriate, and maybe that's where that child is, and maybe it's not. So let's talk about what you're also giving up, or think through that. And, you know, sometimes it's a matter of, well, eventually we might want to outplace, but for right now, it's better to be in the least restrictive environment and in the public school. So we can have that kind of conversation as well. But just wanted to kind of throw out there that outplacement's not always the end goal.
Right.
I have a question.
Right, and
I have a question
right.
from the, sorry, I have a question from the crowd that is germane to this discussion. Is it best to have an advocate or an attorney when requesting outplacement? And then the corollary to this is if you were once in the public school with an IEP and now you're in a private school with no current services and you need to move this child to high school, and the only option is a large public high school, which you don't think is appropriate, what are your options at that point?
Right, whether an advocate or attorney, do you mean?
Right.
Well, there's several questions in there.
Yeah.
There are a lot of questions. I'm sorry.
The answer to the first question is no, you don't have to just have an attorney to ask for an out of district placement. Absolutely
Right.
not. But then there's a whole lot of questions after that I'll let everybody else answer.
Right.
Yeah, I was going to say that there are many times where we're able to get an outplacement through a PPT process where, you know, the team just agrees, yep, unfortunately, we're at the point where we're not going to be able to meet this child's needs. And so let's start looking at programs. But the second question was pretty involved. I think you said that the child is in a private school.
Right.
And needs
So
to
the
come
child
to
was
the
in
public high school.
Now was in public school with an IEP, now is in private school. The private school is ending, and the only option is really the is a large public high school with which the family doesn't think is appropriate. You know, what is the what's the option at that point? Can you ask for an outplacement at that point?
Sure, absolutely. I mean, basically you need to know what the student needs. And so if the only option is a big private or big high school and the child has significant sensory needs or needs small classes or needs some kids need teachers who have expertise in their disability. So in dyslexia and all the teachers and all the classes, that isn't something that can typically be done in a large public high school. Typically, the district is going to say, no, you need to try our program first. I don't agree with that. I think, I know that we need to develop an IEP that is reasonably calculated to be appropriate for the student. And so if at this point, I would be saying get evaluations done to get recommendations for what the student needs, and then to go to a PPT and get that process started and say, I'm requesting what's in the evaluation, and if it's small classes, if it's students of similar ability and disability, if it's teachers with particular qualifications, that all tells you what the placement should be. And that may or may not be at the high school.
And just to point out, placement is sort of the last step in the process.
Yeah.
So, I don't go into a meeting saying we want outplacement.
Right.
I go into the meeting with, as Diane said, we need that great evaluation, that independent person that's telling us what this child needs. We're going to start by, identifying the present levels and work through it, and placements at the very end. So after we've done all of the document, the question then becomes, okay, where are we going to implement? And, if we've developed, this extensive thing where this child, is triggered by large, noisy hallways and, whatever it might be, needs the small class sizes, needs, to be, with children that are, very high functioning or really cognitively, advanced, then maybe that can't be met at the large public school. And that's how you would kind of approach that question. But it's the same thing where I get a lot of calls where I want more speech services for my child. I don't start with speech, that service grid is page 11 for a reason. So there's a lot of steps to get to build the case before we ask for what the child needs in terms of service or placement.
And to your point, Virginia, you need to build, and you need to have documentation to support whatever the parent might be asking for. And part of our role is to guide the parent through that process. What is reasonable? What is appropriate? Really taking the parent's asks and codifying them into something that either can be realized or maybe not necessarily important at that time. To look in other areas and focus on other aspects of the child's needs.
And I feel like it wouldn't be a panel if we didn't ask at least one COVID question.
Huh.
So, you know, what are some of the new trends you're seeing this year? What are parents needing extra help with during COVID? And
Emotional
remote learning?
support.
Say it again.
Emotional support. I think
Yeah.
that anxiety and the level of just school and also school avoidance, but just that unstructure that happened when we were in the forced school closure really impacted a lot of kids. And some kids it was great for, like some kids were not doing well at school and they're accessing their education remotely really worked for them. And for a lot of kids, it didn't. And
Right.
that, you know, so the behavior and that emotion regulation piece is what I see. And that becomes a crisis for the child, the family. But that anxiety is what I'm seeing a lot of.
I know
I'm
that.
also seeing a large lack of engagement for many of my clients' children, that they just don't find it as meaningful to try to be having a conversation or an education process through a screen versus in person. They really crave
What are they
being
looking?
with the person.
What are they
Sorry?
looking for? What are they looking for as the relief that you can help them with as the advocate? What are some of the, you know, I know a lot of them are coming to you very distraught, but are they asking for, you know, things like if they know what compensatory relief is, are they asking for therapy, counseling, or are you more just getting parents who are like, my kid is not getting anything in school, how can you help?
No, compensatory services has been coming up a lot. So basically, if the district wasn't providing services that the child needs, and the child either is regressing or they're not making the kind of progress that they should be, the district might need to provide what they call compensatory services to make that up. And in some cases, districts have reduced the amount of services they're providing kids right now. Apart from the IEP, they do it through what they call a learning model IEP implementation plan. That's something the state just kind of made up. It doesn't actually exist anywhere in the law. But it basically says these are the services we're providing when the child's remote or in hybrid. And a lot of times they've been reducing the services. So we've been negotiating to get those services made up. Or I have some kids who could not benefit from remote learning. And at times schools need to be or have needed to be remote. So we need to make up those services as well.
That brings up sort of an interesting question as to, you know, as we see a lot of schools are, you know, are still on kind of a remote or hybrid, you know, type of model. You know, if a child requires in-person learning and the district is not providing in-person learning, does that constitute a violation of FAPE?
It's not so much, I don't call it a violation of FAPE. I just say we need to request in-person learning for this child.
Right.
Whether if it can't be done in district, we can hire a consultant, have the person potentially come to the child's home, have the child, there are some private providers that are, you know, their offices are open. We can ask the school district to pay for it. So yeah, FAPE is still in effect. You still have to get an appropriate program. The federal government has said that there may be an inevitable delay due to the pandemic to get some services. So it's not a blame issue. You can be understanding, you know, the schools are overwhelmed. We're dealing with the pandemic. At the same time, we still have a responsibility to the child. And so if there's a way to meet the child's needs right now, then we need to do that.
What parents should also know is that most districts have put sort of a high needs priority group into place. And if you don't know about that, you may want to approach the district and say, I really think my son or daughter would meet the criteria for this high needs group. What is the criteria? Let's talk about it. So yeah, but I think, you know, listen, there's been a disproportionate impact on kids with disabilities from the pandemic. My experience is that, like Virginia said, some kids have done infinitely better. And for others who parents have had to stay home and actually see what's going on, their eyes have opened wide and they've realized, oh my gosh, the skills that my school said my child has they don't have. And it's been very illuminating and helpful toward, okay, let's press a reset button on what's going on here and let's try to make things better. But I also think that there's been a huge, as to Diane was alluding, a huge misinterpretation of the state guidance on what those model IEP implementation plans need to be. And some districts have summarily, like, just reduced it by sort of a formulaic approach. And so many parents have called me to sort of get those services back in, or just like Diane said, they can't be in school for one reason or another. How do we build a better mousetrap here so that my child can actually benefit from education?
I've had a couple of districts say that they just can't provide the service because they can't find the staff. And it's a real problem. There's such a shortage of teachers. In our own district, the school shut down for 2 days, not because there was a COVID outbreak, but because one teacher did get COVID when they weren't in school, it was obvious, and therefore they have to quarantine a whole cohort of teachers. And they couldn't find enough staff to support that. So, there's a level of patience that unfortunately we all have to put into place here, but it's, if you can't find the staff, I don't know what you do. So really we're about documenting to just make sure that we have clear data on what did not occur or what was not able to happen because of COVID. And, hopefully we'll be out of this soon and we can start to regroup and regain some more services for students.
Well,
in some areas.
And to your point, and I think Diane, you might have said it too, I've been using, nobody's arguing that the child doesn't need a one-to-one RBT para or whatever it is. So if you don't have it in district, we need to be looking at the BCBA groups that do. And I have districts that don't necessarily want to go that route, but they do because they have to. We're not in disagreement that the kid needs the service or the support. We're only in disagreement because we can't find it. That's not really the answer ever. And so that's when I ask that question, they might not like it, but magically we find a provider that can provide.
Exactly.
Yeah. And as time goes on, there are more and more of those providers that are available to do in-person services because, 6 months ago, that was pretty slim, but that's changing quickly as the vaccine rolls out. So that's beneficial for families.
I have one final question from the audience, and then, we're going to wrap up because, you guys have been so generous with your time and with your expertise and with your knowledge. This is in regard to, a child that's been outplaced by their district and is, by all intents and purposes, staying in that outplacement. Does the district have the right to conduct an evaluation if it's time for the triennial, if the parent doesn't want them to? I think the answer is yes.
No.
No.
Basically the right to evaluate, the parents can refuse consent for evaluation. They have the right to do that. However, that can blow up on them. So if they're looking to have the district provide services or appropriate services, and if there's any possibility they may want to contest the district's services, they absolutely do not want to refuse to let the district do the assessments that the district says they need to develop an appropriate program. So a lot of times people say, I don't have confidence in my district, I don't want them to evaluate, which I totally understand. The thing is, if they don't let the district evaluate, the district is essentially off the hook for providing an appropriate program. And so that's one reason to do it. The other reason is if the family disagrees with the findings that the district has, they have a right to request that the district pay for an independent evaluation with someone the parent chooses. So to just keep in mind, if the district does testing that the family doesn't agree with, that's not the last word. They still have an opportunity to get further testing that the district could pay for.
And it was sort of one of those questions that has a couple of layers to it.
Yes.
Right. And also you have to think about it this way. I mean, you know, the school district is legally obligated to evaluate the child every 3 years. Why do we do that? 2 reasons. Does the child remain eligible? And if so, well, what kind of progress did he or she make? What kind of what did they not make progress? How do you continue to plan for a child if you don't get fresh information every 3 years minimally? So I think Diane's point is it could be very counterproductive to refuse any updated evaluations regardless of who's doing them.
And I think
Chris, sorry.
I was just going to say it highlights how complicated it is to have these questions that seem like it's a yes or no answer, and it's
Right.
And then everybody's saying yes and no at the same time. Yep.
Right.
Well, I think the wrench in this was that this student is outplaced currently,
Yeah.
right, Christine? Did I hear
Yes,
you? Yeah.
that's right.
So that it does turn a twist on it. But if the child is ever going to go back to the district for any reason, yeah, it could get very sticky.
Right.
Well, and
Go ahead.
Oh,
Sorry.
I see.
They're
No,
outplaced.
actually, I'm looking at the question. And specifically, they're saying they're up for a triennial 3 years after the IEE. The district already paid for an IEE. And now does the district have the right to conduct their own evaluation? So yeah, you don't get an IEE automatically if you already had an IEE.
Right.
And if you're outplaced too, you have the outplacement school that is also part of that team and informing decisions. So I don't think you do yourself any favor by not having them evaluate. But regardless, the outplacement school is going to be part of that discussion, which is helpful.
And will often be the party doing some of those assessments. Yeah.
And we'll recommend areas of assessment too.
And usually they recommend, whether the child has been successful, not successful in staying, and that carries a lot of weight with that placement school carries a lot of weight at that point.
It's a difficult sort of line to because you're on the one hand having been in this situation myself where you're like you want to show that the child's made progress in the outplacement but not too much progress because they're not ready to move back, so you're sort of like towing that line of and it is a difficult one, and it is scary for sure.
Right.
Well, thank you everyone for joining us. I really appreciate all of the time, all of the questions, all of the expertise from our panelists, from our attendees, and thank you to Virginia, to Diane, to Anne, to Julie, and to our moderator, Lara, for this really amazing discussion this evening. If you missed any portion of this recording of this webinar, the recording will be available at some point later this week, hopefully tomorrow. Thank you all so much for joining us, and have a great night.
Thank you.
Thank you very much.
And
Bye-bye.
Okay, bye.
Bye-bye.